Thank you very much, Senator Hawley. Let me just reference again the statement made by Ms. Ingram to an enormous audience on Fox News regarding this particular question before the court. I'm quoting her here. "I think it's time to do what Robert Bork said we should do, which is to circumscribe the jurisdiction of this court. And if they want to blow it up, then that's the way to change things finally." It is funny how the expressions of dismay about efforts to influence the court managed to overlook that effort, which probably had the biggest audience than any. I think that the premise for this hearing, which I think has been very helpful and instructive, has been exactly what Senator Lee just said. We don't want a court that is influenced by political influence operations. I think we have very different views on whether that court is already there. Clearly, the court is a great place for people who want to capture an institution to get their way because it defeats democratic principles. If you're stuck pushing policies that the public hates and that Congress won't pass, then controlling the court and pushing those policies through in a way that defeats democratic correction is a wonderful, wonderful thing. And the backdrop to all of this is some recent history, which is that the recent nominees to the court were selected by and through a private organization, which is pretty darned unprecedented in the history of this court, if we're talking about what's been unprecedented. And they were selected by and through a private organization that at the time that it controlled the turnstile to the court was receiving very significant anonymous contributions. I think if we were to send a delegation to another country which had a judicial selection process that put this judicial selection in the hand of a private organization funded by interests that don't even have to disclose themselves to the organization, with no transparency about how the judges were selected, we'd be very solemnly instructing that country that that was a terrible way to appoint justices. And yet that's exactly what we have been up to in this country. And once the judges are selected, another operation goes into effect to campaign for them, spending tens of millions of dollars, receiving checks as big as $15 million from people who hide their identities when they write the checks. If you add that to the list of concerns in that foreign country that you might send a delegation to, that would just make it even worse. And then you add in flotillas of front groups that seem to have no purpose other than to hide who's really behind them, who come in an orchestrated combination to pitch the court, thus selected and thus campaigned for results that they want. And then you look at the win record of those particular organizations. It's not a pretty story. And it's no small thing, because the latest information is that $580 million was spent to perform this. So we're not starting from a clean slate. We're starting with a court whose members have been chosen by special interests secretly, and which in turn has been delivering win after win after win, almost always in partisan, narrow decisions that benefit those very interests. So far from an effort to delegitimize the court, I see this as an effort to re-legitimize the court by bringing it to very reasonable standards, the standards to which the executive and legislative branches already adhere, the standard to which our district and circuit courts already adhere, and to principles that are so long-lasting in our society that they began in Latin. The thing that is peculiar right now about the court is the variation from the norm of the selection, confirmation, and solicitation of justices by enormous, enormous, enormous floods of anonymous money. And I will stand with Judge Selya of the First Circuit, a Rhode Islander, who in a recent decision that now stands, because the Supreme Court declined to review it, described how it's one of the very important attributes of citizenship that citizens be allowed to understand who is doing the talking. Citizens have an important role in our democracy. And if you disable them from the most basic element of knowledge of who is doing the talking so that everything comes to them from behind masks, from behind front groups, from behind organizations that they know not to be real in their real lives, it does enormous damage to our democracy. And in court, it gets even worse. The judges in a court, the other parties in a court, and the public watching a court proceeding have a right to know who is showing up and what their motivations are and whether they've all been orchestrated by an outside influence. You'd think that a principle like that would be non-controversial. That seems like pretty basic stuff. So I hope as we work our way forward, that type of common sense and long-standing principle can prevail in this discussion. And I will ask that a letter that Senator Lee would like to have put into the record from an article by Jeffrey Rosen through the American Enterprise Institute be added to the record of these proceedings, and also a letter that I will ask to be put in from the Leadership Conference on Civil Human Rights be put into the record. And I would also, since time has expired, ask each of the witnesses to reflect on the situation in the recent case of Americans for Prosperity Foundation versus Bonta. And the facts that I would like you to reflect on are that Americans for Prosperity is the political battleship of the Koch brothers' dark money political operation, and it spent millions of dollars pressing for the selection and confirmation of the last three justices, which would seem to implicate Caperton versus Massey. And Americans for Prosperity Foundation is the 501c3 twin to the Americans for Prosperity 501c4. This is standard operating political practice now. You twin a 501c3 and a 501c4, and you get the tax deduction and the secrecy for the 501c3, and the 501c4 can act politically, and they very often have the same staff, same location. The way I describe it is that the corporate veil between these 501c3s and 501c4s could be pierced with a banana. And yet, in deciding the Americans for Prosperity Foundation case, none of the justices even discussed the question of whether they should treat that petitioner as related to or even identical in fact to Americans for Prosperity, and consider whether or not Americans for Prosperity's millions of dollars in spending to get them on the court should justify recusal. Now, I think it's an obvious, they should have recused. Boom, slam dunk. I think that's an easy call. They may have a different view and they're entitled to have a different view, but they should relate that different view so that people know what the recusal standards are. To Mr. Dupre's concern that there will be a surge of activity if we open these gates, yeah, and that surge of activity will define the rules so that everybody understands and so that the rules themselves are open, and it puts behind us this era of everybody being judged in their own cause with no accountability, with no consistency, and with no apparent principle. So anybody who cares to respond to that AFPF, AFP situation, I'd be delighted to